Good morning, everybody. Welcome to another C.L.A. title training. Thank you so much for joining us. As you guys know, we host these trainings once a month at least with various hosts. It's either Joel or lovely Jim Savitz here. Today, we're going over a very popular topic. It's a broad topic. So Jim's going to be covering things that are most important. It's how realtors can avoid settlement problems. And we have Jim Savitz here. He is our Senior Vice President at C.L.A. Title, as well as our title attorney. He's been in the business for 30 plus years, a long time. We're super proud to have him on the C.L.A. title side. And thank you, Jim, for joining us today. We would love to hear all of your expertise on this topic, and I'll let you take it from here. Thank you, guys.
Thank you. So, hi there. Good morning, everybody. Nice of you to join us. This is an interminable topic. I could talk for hours. In fact, I used to do a 3-hour class on avoiding settlement problems. Nobody could sit still for that, but we'll talk about some of it. And when we get too far in, maybe half hour or so, I'll call it a day and we can do it a continuation some other time next month. You know, the problem with avoiding settlement issues and problems is that it starts way before the actual settlement. It really begins with how you, the agent, have set up the expectations of your customer. And so many agents either overpromise, underpromise. It's crucial that at the beginning of the relationship, you've set the proper boundaries. And I remember when I was a rookie lawyer, and if you could fog up a mirror, I'd take your case, whatever, walked in the door. And as time went on, I was able to not only be selective, but to recognize those people that I really should not be working with. And agents kind of need to do the same thing. You need to evaluate the potential client and sometimes say, you know what, this is not a good match. We're not going to be able to work together well. And I know it's tough to do that, but to avoid a potential problem down the road or a complaint, take a real close look at the customers. And see, what are the seller's realistic expectations of what they're going to get out of the property? As long as I've been in the business, I would be a horrible seller, because I always think my house is worth way more than it's really worth. And my wife always brings me back to earth. But make sure that your sellers have a reasonable expectation. And the same thing on the buyers. It's interesting as well. Make sure that they're qualified before you go down the line very far with them. And I would make sure that my buyers have consulted with a lender who can give them some reasonable idea of what to expect and what they can afford. One of the problems is, and I've seen this happen so often, the lenders will qualify people very often for a loan that they qualify for, but they would be very uncomfortable paying for on a go-forward basis in their life. And I've seen it happen, again, frequently. So you need to reconcile what can you qualify for and what can you really afford. And again, the communication with the buyer early on will hopefully avoid some problems. You know, one of the things that I recommend that very few agents do, at least very few that I'm aware of, is I think it's important to give the clients, both sellers and buyers, a copy of the contract that they're likely to see. Give it to them at the beginning. Let them look it over. Let them study it. Because from a seller standpoint, you put the property on the market, an offer comes in with all these 30 or 40 paragraphs of conditions, and now all of a sudden the seller wants to try to understand it and have you interpret the contract or explain it. And what you really should do is give them a copy and tell them to study it, to familiarize themselves, and that goes for both buyers and sellers. By doing that, when you get down the road and are heading toward settlement, they're going to be hard pressed to say, well, you didn't tell me about this, or you didn't explain that, because you've already given them the contract, you've given them the opportunity to review it and to study it. You should absolutely use the official Board of Realtors forms. A contract, addendum, the whole bit, only use those forms if you can, because that becomes the standard of care in the industry. Even if the form is a crummy form, I'd still use it, although most of the forms are quite good. But if you use the Board of Realtors forms, you're less likely to have an issue or a problem. So when you get down to writing up the contract, please, please, please make sure that you've completed all the forms and addenda correctly. Basic stuff, the legal description and the address. It's amazing how often I get a contract and either the legal description or the address or both are incorrect. What happens on frequent occasion is that the agent will have written an offer, the deal doesn't go through, so they write another offer, but they don't take care to correct the legal description on the offer that they are making. So it's something that you need to be very careful. And I know in my local jurisdiction, I don't know where everybody that's on here is from, but in our local jurisdiction, I can go to the land records and pull a copy of the last deed, which will tell me exactly correctly what the legal description and the address are. In addition, I'm going to want to make sure I've identified the correct sellers. And I can do that by looking at the last deed. Going to the Board of Realtors forms, very often they pull information from the tax records, and the tax records may be inaccurate, whereas going to the deed is always going to be accurate. And you need to make sure if the sellers are people, individuals, Is it an LLC that's a seller, a corporation, a trust, or some other entity? And if so, you need to deal with that. As a listing agent, if your seller is an entity, you're going to want to get copies of the organizational documents. And I'm not going to go into that in any depth right now because I'm going to discuss it at another program. But just be aware that you're going to need to help your sellers understand that they need to provide the organizational documents. Or is somebody planning on using a power of attorney? If they're planning on using a power of attorney, there's a lot of issues that arise. And my first big question is, why are we using a power of attorney? The title underwriters tell us that one of the largest fraud situations arises because of the use of a power of attorney. Who prepared the power of attorney? How old is the power of attorney? If there's a power of attorney to be used in the purchase or sale, you should absolutely run it by the title company far in advance to make sure that it's an acceptable, usable form. And we'll review it. And very often we need to recreate a power of attorney and do a new form. But what if the person who granted the power of attorney is incompetent, incapable? You run into a lot of issues. Now, there's a lot of other little things that you need to make sure you all understand. If you're dealing with a homeowners association or a condo association, try to get a little bit of information on that so you understand what your buyer is perhaps looking at. I just saw a condo that was on the market for $160,000 and the monthly condo fee was about $1,250. Well, that's swell, but if you're showing it to your customer, why bother if they can't afford a $1,250 monthly condo fee? And it would be productive if you can explain, it's a homeowners association or a condo. From what I've been able to learn from the association, the fees are approximately X. And at least you can give them a heads up. And while I'm talking, I'm reminding myself of something else too, and that is any information that you get from another source, like from the land records or from the homeowners association. Agents, it's very important that you identify the source of the information. Instead of saying condo fees $1,200, how about you say, according to so-and-so at the condo association or the management company, the condo fee is X. Because you really don't know except the information that you've gathered from another source. Agents, it's also important with your buyers to find out if they are buying the property for a specific purpose. Do they want to have an accessory use for their aging parents? Do they want to breed puppies or have horses? Or what do they want to do with the property? You need to find out so that you can make sure that their wishes are being accommodated. A number of years ago, I had a couple that was buying a house and they were ham radio operators. And they did tell the agent, we want a home that's not in a homeowners association because we want to put up a tower for our radio. And the agent searched high and low, finally found a lot that was not in a homeowners association. And they put a contract in, and it was accepted to buy this property because it wasn't in an HOA. However, what the agent hadn't checked on was, were there covenants, conditions, and restrictions, which there were in this particular case. And guess what one of them said? You cannot have a radio tower. And so after the contract had been ratified, these buyers ordered the tower, which was being delivered in some giant truck. And here they are, they're not allowed to use it. And where does the agent stand on this? Unfortunately, they couldn't put up the tower. They were actually pretty nice people because they could have sued the agent for any of the losses they suffered. And in fact, there was a $5,000 restocking fee for the tower, which the agent paid for, but the buyers at least went ahead with the purchase. The $5,000 at that time pretty much covered most of the commission. So the moral of that story is make sure that you find out, what particular use your folks may want to put the property. And I suggest early on, you have part of the conversation, is there something special that you're looking for? And there are court cases where people wanted a house where they could have an accessory apartment for the parents. They bought the property, and it turned out the zoning didn't allow accessory use apartments. So, you can't know everything, but if you ask questions, you'll at least know to call me or some other lawyer and get answers for your customers and try to minimize the problems. Now, one of the other things that happens very early in this contract process is that the folks need to post their earnest money deposit. And shockingly, a lot of people don't know the difference between the earnest money deposit and the down payment. So you need to explain that. You're going to put up some money to help ensure and satisfy the seller that you're serious about performing. Expect all monetary transactions to be by wire transfer. And we've all heard stories about wires being misdirected. And that's because people have used the ordinary email. Don't use ordinary email to receive or send wiring instructions. Usually you will have access to a secure portal. We use the Qualia platform, which is supposedly secure, and I believe that it probably is. And I always suggest you pick up the phone and call right before you send the wire, just to make sure that everything is on the up and up and nobody has messed with your wire. I had a case long ago, which was the classic story. The title company had been hacked. The buyer went with their agent. It was an elderly buyer, and he went with his agent to the bank and directed the wire, went to settlement. The title company said, well, I'm sure the wire will arrive in the next few hours. Well, the wire was somewhere in South America at that time because it had been redirected. And always, again, use the secure portals and or call the title company, speak to someone with whom you're familiar, and reconfirm the wiring instructions. You know, when you think about earnest money deposits, one of the other issues that comes up is if there's a breach or a default. Agents often don't understand, why do we need a release of the contract? The darn buyer defaulted. They said they're not going to buy this house. I'm going to put it back on the market and sell it to somebody else. Well, it's not quite that simple. There's a concept called equitable title or equitable conversion. And that concept exists in the Maryland, DC, Virginia area. It's in Florida, for if anybody on here is from Florida. An equitable title occurs when a contract is ratified and the parties have the right to force a purchase and sale of the contract, of the property. So for example, the buyer and seller sign a contract with the rights to force a purchase or sale. The buyer defaults, seller puts the property back on the market, gets a contract. But wait a minute, now that first buyer comes back and says, wait a minute, under equitable title, I have all the rights to that property. And now I think I want to buy it. What do? You've sold the property twice, and it's actually the first buyer who has equitable title. So as painful as it is, if you do have a situation where there's been a termination of a contract, you need to have a written release of that contract. And I know it gets complicated because people will often, all they care about is getting their money back if they're the buyer, and all the seller wants to do is forfeit the deposit, and they may not care about the equitable title, but they're fighting over the money. So if you get into that situation, and take 2 aspirins and call me in the morning, we can talk about it. Getting close to a half hour, but I still feel like talking. So you're stuck with me.
Talk as long as you'd like. This is great.
You know, one of the other things that you need to address is the law of fixtures and what conveys when you're drafting the contract. Most of you recall the law of fixtures, which is anything that is attached to the structure conveys. But agents, you really, as a listing agent, you need to look through the property and see what's going to be an issue. You know, is the Waterford crystal chandelier really going to convey? I think the thing I've seen with an issue the most often is Ring doorbells. The seller wants to take the stupid doorbell, and the buyer saw it when they signed the contract, and it was attached to the property, and therefore it was a fixture and it conveyed. Somebody just put up a note about TV mounts. That's a fabulous issue, something you need to deal with, because again, if it's what conveys, it's a fixture if it's attached. So you go in the family room and there's an 80-inch plasma, fabulous smart TV, and that TV is hooked to the mount, and the mount is screwed into the wall. Well, if you go by the law of fixtures, that whole TV, everything conveys, but the seller never planned on that. Now, one of the primary contracts that we use in this area has an addendum that says electronic devices don't convey. So the TV wouldn't convey, but it doesn't address the mount. And agents, what if we say, okay, you can take the TV bracket. That's cool, except when you take the TV bracket, you've got these 4 giant holes in the wall, and who's gonna repair them? I don't know. You need to think about this and address it at the time that you're drafting the contract offer. If you don't, there's going to come a time, either at the settlement table or before, when someone's going to look at you and expect you to pay for it. Not interested. And I've lived with the law of fixtures for a long time. And there's a local planned community, Montgomery Village, that was one of the lead planned communities in the country. And this many years ago, maybe 30 years ago, I dealt with this a lot. If there was an antenna, and for those of you that don't know what an antenna is, you young people, it was this thing that helped you get reception on your TV. But if you had an antenna for your TV, you could not mount it on the roof. The only place you could put your antenna was in the attic. And if there were 2 ways to install an antenna, one was to hook it on the rafter in the attic, in which case it was not a fixture and did not convey, or you could bolt it in to the floor of the attic, in which case it did become a fixture and conveyed. And based just on that simple thing, we got into lots of battles about whether it conveyed or it didn't. And again, I don't care what you agree to, but it just is important that everybody understand the situation and come to the same agreement. I had one deal years ago where the sellers had this kind of a not great kitchen, and they had built a kitchen cabinets, a countertop, the whole bed that matched the kitchen, but it was on wheels, and it literally took up like half the kitchen with all these cabinets and stuff. And the buyers showed up at the final walkthrough, and lo and behold, the sellers had taken the whole half of the kitchen with them because it was not a fixture and it didn't convey. That took on some other issues like misrepresentation, some other things that I'm going to talk about in another day, but it was just kind of interesting that it wasn't, it really was not a fixture. They rolled half the kitchen onto the moving truck. So it's so important to understand what conveys. Playground equipment. I promise you, when the seller leaves the playground equipment, the buyer's going to scream and shout, why didn't you move that trash out of my backyard? It's a danger. People can get hurt. Get that out of here. On the other hand, if the seller takes the playground equipment, the buyer's likely to say, you know what, the only reason I bought the darn house was because of this lovely playground for my kids or grandkids. So again, I don't care which way you go, but please make an effort to go through the house and the yard very carefully and identify clearly what it is that conveys or what doesn't convey. Are there leased items? Water softener, alarm system, propane tank, and my number one top 10 crisis today is solar panels. If they are leased and they're attached, that's a real problem because those leases can be pretty onerous. The last one I saw was pretty expensive. It was a 20 or 23 year, I don't remember, 20 some year lease. But at the end of the term, the owner of the house owed like $20,000. And that's really, in fact, I saw the deal die, and I've seen a couple deals die over that. So again, agents, when you're looking over the property that you are going to make an offer on behalf of your client or a seller, if you're about to list the property, I urge you to carefully go through and identify items that are going to be of potential concern, like the solar panels and the Ring doorbells. Those are the top two that I see, and it's just kind of silly to fight over those items. They should be identified. So many other things I can talk about, but I think I'm going to call it a day for today, Ida. What do you think? And we'll pick this up again. We'll pick this up again next month because I got about a quarter of the way through.
I'm sure you have a lot more to cover. And like I mentioned, it's a broad topic, and you know, Jim, you have so many different things and avenues you can go with this. But like you said, and for everybody who wasn't on in the beginning, we're going to make this into a series. So every month, you know, hopefully we'll have another training on another topic of choice, and then Jim will do his series on everything that relates to the settlement and settlement issues. So if anybody, does anybody have any questions while we're on here? Questions? No. Okay, so we will end this here today, everybody. Thank you, Jim, for being on. Thank you. Thank you to everybody else. We will pick this up again next month. And this is recorded, so we will send the recording to everybody who registered and everybody who wasn't able to attend. So thank you.
Next time I want to start, Ida, talking a bit about some title insurance issues that people need to be aware of. So
perfect.
We'll pick it up there.
Great job, Jim. Thank you, everyone. Have a great day.
Bye. Bye.